him until he died. Hello and welcome to another program on Law and Order on a Friday evening. This week too, we have a special guest and we're going to talk to you about the changes that we need in law. That is the topic we are going to talk about. Not about all the law, but for today, specified or limited to one area of law that is a very important area of law, that is the criminal law. And none other than to talk about this area is a specialist, a long-term practitioner on criminal law, is our present President of the Bar Association of Sri Lanka, Mr. U.R. De Silva, President's Counsel, is my guest today. First of all, Mr. U.R. De Silva, thank you very much for joining in, and congratulations on becoming a President's Counsel.
Thank you very much, and I am thankful to you all to inviting me for this program, and this is the first program where I am participating as a President Counsel.
Yes. So, you have, other than your work in the Bar Association and for the profession, is a lot now, because you have become now the President of the Bar Association a couple of months ago. We were wanting to talk to you about the changes today in criminal law, as we are titled, the changes in the Criminal Procedure Code. Now, I understand the suggested changes. There are three major areas. So one of the areas is the Section 6A, which is about police representation. What are the changes, Mr. U.R. De Silva, that is going to take place with this amendment, and why is it necessary?
These changes, of course, the first change we are talking about is the representation can be made to a police station by a lawyer. So that is a very essential and important thing. Now, after appointing a special committee headed by Justice Bonika Alubihari, President Counsel, to consider amendments to the Criminal Procedure Code, and this was a major suggestion. And because right through we have been denied to go to a police station and make representation, because now if you know the police officer concerned, then we can go and meet them and do whatever we want. But the fact remains, especially for the juniors, they can't go there and make representation. So for that, of course, we are trying hard to do that, and finally we got the benefit of getting as a permanent law. So the other amendment is there, so it is being considered as a important amendment, because now it has been recognized that a lawyer can go to a police station and make representation. So earlier it was a gazette notification where the police officer can say, I don't have the gazette notification, or it's not law. So as of right, we couldn't go there. So now it has been recognized that a lawyer can go into a police station and meet, firstly they can meet the OIC relevant and ask why your client is being taken into custody. As soon as he is being taken into custody, it should be informed to the suspect that you can have a lawyer, and that lawyer can go to a police station and make representation.
Yeah. Why do you think this becomes necessary in a police station?
Yes, that is because now at the first instance, the lawyer should know, or the litigant has to have that confidence that I have been represented by a lawyer, and the lawyer can go to the police station and ask why he is being taken into custody, and on what basis they are going to interrogate, and on what day he is being produced before the magistrate, and whether it's a bailable offense or not, whether the police are ready to grant bail or not. Those factors can be obtained by the lawyer from the police. So that is very important, so that we accordingly we can act on that and do whatever necessary steps. And in the meantime, there is a special provisions where it was done to the Criminal Procedure Code earlier, that it is specifically mentioned that if you are going to take up an alibi position, and if it is so, then you have to come out with that alibi position at the first instance. It is specifically mentioned. Then at the first instance means that when he is being interrogated, he should come out and say that I have been there, I was there in some other place. So if he is going to take up the alibi position, the police have the material to find out whether it's a correct position or not. It is very useful to the lawyer, to the suspect as well as to the investigator. So both are benefited by. So that factor, of course, we can inform the suspect if we are in a position to go and meet him. And at the same time, if he is going to be produced for an identification period, we should give necessary instructions to our client how you should be present on that occasion. And then if they are going to take up the confession, of course the things that should be included, and then on what basis he should come out with. Those factors, of course, can be elicited from the suspect if you are in a position to go and interrogate him. But the fact remains, now there is though it has been recognized as a law, but in the same provision there is a special clause where they say the police officer can say that since the investigations are going on, we are not in a position to allow you to go and meet the suspect. So that, of course, we have to observe and see whether they are going to delay purposely or not. At the moment, we know some police officers are not adhere to the law. So that is the very reason the Bar Association is particularly concerned about that particular section, as well as another section. There is another section where it is specifically mentioned that if you are going to be the side of the suspect while the interrogation is going on, that statement can be used to some extent without violating the evidence ordinance. So that is also, at the moment, lawyers are concerned. So we are discussing whether it's a fruitful thing or it will be not beneficial to the suspects, and then we will come out with suggestions with regard to those particular areas. But overall, we are happy that the ministry has decided. The minister concerned is Vijayadasa Rajapaksa, President Council. Since he is also a lawyer, he is very concerned about this particular section, and then that is why he asked the authorities to have this particular amendment to the Criminal Procedure Code. Now we, as of right, we can go to police station and get all the information from the OIC.
Right. Thank you for that elaborative explain. But there are two other sections that are also going to be amended in the Criminal Procedure Code. That is 144 section, that is production of a suspect before magistrate.
That's right.
What is the amendment now that is going to come with
Chanakya, now you have seen that very recently there were a lot of incidents where when the suspects are being taken to the courthouses or from the courthouse to the remand prison, shooting incidents were there, and try to abduct the people, try to murder them. So because of that, the authorities has decided without bringing those people into the remand, from remand prison to the courthouses, are we in a position to extend the remand period, only to extend the remand period without producing them. So that is the very reason that this amendment has come in. And because of that, the lawyer can appear on behalf of the suspect. It was not denied. So the lawyer can make any suggestions or any submissions with regard to the particular suspect who is on remand, but physically it is not necessary to produce him before the magistrate to extend the remand. Now, if he wants to make an application for bail, certainly the lawyer can make that application. And if he wants to say that the suspect is needed any medical representation and medical advice, so then he can ask the judge to make that order. So what the authorities are saying is that without producing physically to courthouse, they can, the learned magistrates can extend the remand period. So they are going further more and say through Skype, they can see whether physically he is fit or he has any injuries or not. They can see that. So we are using the technology to this particular section, and I think it's a very good suggestion. And then we are in support of that suggestion, and because the authority has decided that the lawyer can make any representation before the magistrate even without the suspect.
Yeah. Now, doesn't it also fast track the process?
Yes, that is certainly yes, because now
to bring a person all the way to from the prison is
a lot of problems are there,
and there are timings.
Now, time concern is there, because if they are bringing these people now every day, they have to be present physically, and then it will take some time. But at the same time, the authorities have a lot of problems by bringing them with lot of squat.
Yes.
So they have to be given a lot of protection. So to avoid that, we have decided on that particular section.
Right. Now, the other section that is going to change the CPC is 431. Production. Yeah. Why was this necessary to change?
So that is also, Chanakya, very important section where we see when we go to a courthouse, we see lot of productions are lying. They are on the compound. So unnecessarily. So ultimate result would be that the person who is having claim, if they are ready to claim that they can't get the production back, and if it is being confiscated, even that also the government can't get the maximum out of, because you can't use it. So without delaying, the magistrate can get the photographs done, and thereafter these productions can be released on a bond. So if there is no proper claimant, right, then within 3 months' time, earlier it was 6 months, within 3 months' time, the magistrate can take a decision, and then thereafter it can be auctioned, and then the amount can be deposited with regard to this particular courthouse case number. So at the end of the day, if it is the claimant's position that it should be given to him, the money can be handed over to him. Otherwise, automatically it will be handed over to the government.
Yeah, this also will prevent things being decayed.
Certainly, yes.
Which is a bigger problem.
Bigger problem, and nobody is gaining it.
Nobody is
ultimately,
gaining.
because now there are provisions where they say that the productions can be confiscated. So what the government is gaining?
Yeah, when you have a decayed product.
The decayed product. So that is the very reason, and unfortunately, some of the learned magistrates they are reluctant to do so because of various problems. So when they are going to auction, there should be a procedure adopted. So to avoid that, now at the moment, the ministry is giving necessary instructions to JSC to go ahead with these productions and minimize the decay.
Yeah. Now, are these amendments already in force?
Yeah, some of the amendments are already in force, especially section 6A at the moment they are discussing, and they will come to a finality in near future.
Right. Apart from these three areas, do you see any other areas in the Criminal Procedure Code which needs changes?
Yes, there is one other section where the 420, section 420 of the Criminal Procedure, where it says admissions. Now, at the moment, admissions can be recorded once the charge sheet is filed.
Right.
So my position is that if you are going to amend this and allow the lawyer as well as the suspect together and give an affidavit and say that they are ready to admit some of the facts, then the whole court procedure can be curtailed. So now, for example, with regard to cannabis sativa, we call as ganja. So now what they do is they take ganja into custody and send productions to government LDs unnecessarily, because now government LDs will give only a report with regard to that the production is called cannabis sativa oil. That's all. They are not relying in this particular area. The court is not relying on the government analyst report with regard to amount. So they can't say pure ganja or not. They are not going to do that. So merely because that to find out ganja or not, they send it across to the government analyst. So without doing that, if our position is, the suspect's position is that I didn't have that, it was not in my possession. So on that basis, if you're going, you can admit that production as ganja and ask the authorities to file charge sheet immediately. So then the suspect won't be there in remand for years. So apart from that, other areas also with regard to the things that can be admitted. So it can be done before the charge sheet is filed, especially with regard to the money transactions, where if they say I am going to pay that amount, at the moment legally you can't do so without filing the charge sheet. So if the lawyer says that my client is ready to pay it in installment, judge can immediately record those admissions under 420, and it would be very easy to finish these matters without going for months and months.
Yeah. Now, these ones you want to change, are they being discussed now or are they
Certainly,
being drafted?
No, it has been discussed at the moment. We have suggested to the ministry, and they say that those are good suggestions, and then they are going to consider immediately. They will draft a special amendment and then bring to.
It will be better if you can have all amendments coming up one point, right?
Unfortunately, it cannot be done, because now immediate things that they are going to attain. At the same time, there is a permanent committee where they are going to have these amendments. So in that committee, they are considering various sections to be amended. So I think, as you said, that committee will give a comprehensive report to amend various sections at once.
Right. Now, apart from the Criminal Procedure Code, when you look at the other laws also, there are things that we wish to be changed. If you look at the Penal Code, do you have a suggestion of areas that you would like to be changed?
Yes.
Or added on?
Yes. Now, there is section called 296, where murder. So now if we can say that 297 can be included in an indictment, so that factor can be considered as an important thing. At the moment, there are no indictments coming with regard to 296,
right.
No 297. So then we have to wait and see whether it can be done. So beforehand, if we can come to conclusion whether we are taking up the position at the non-summary inquiry, whether the 297 can be included, it is very easy for the Attorney General to send an indictment with regard to 297.
Yeah. Offense like abortion.
Certainly, that's also being considered, and now the special committee has recommended that after in consultation with the medical field, and they have given a lot of good suggestions, and we have considered those suggestions, and then we are of the view that as far as the rape charge is concerned, if the victim says that I want to have this abortion done, and then under 16 age girl, if she wanted to have this abortion done, and then with medical representations can be made, and then medically the doctor can decide on that, and thereafter it is being called as legal abortions. So the suggestions have been made, and very recently I think they are going to amend these.
Yeah, what is the law as it stands?
The penal code, the abortions are prohibited.
Yes.
That's an offense, actually. So only the doctors can, with very rare occasion, can do that. But if we can include those areas also on an exception
of the penal code.
That's right. So then the doctors are in a position to go into these things and do legal abortions.
Is it the trend in other laws in other countries?
We have considered in various countries. We went into those areas, and a lot of laws are being considered, and then only we thought that those are very essential at this stage.
Right. Now, one of the things about Sri Lankan criminal justice system is we don't take motive as relevant. It's only the intention.
At the moment.
At the moment. But if you look at the jurisdiction of the United States, you find they take motive relevant to certain instances. Do you think, why do you think that in those countries, some other countries, Western countries, they consider motive necessary, and why don't we? And will it help for us to also take motive as a relevant factor in your deciding criminal
Certainly
cases?
it will help, because now it will curtail the criminal investigations also, because if we are in a position to show in evidence that the motive of that particular offense, then it's very easy for the prosecutor to prove that charge in a particular way. So, but the problem would be, how are we going to investigate, and what sort of evidence we can have into this particular trial. That is the area we should look into. So if the investigation properly done, and then the particular investigator can find out the motive through evidence, then it can be used as evidence in the particular trial. So my position would be that it is very relevant, and if we can use it in a proper way, without having it in a ad hoc way, so then it will be very useful either party also, because the motive, of course, if it is a sudden fight, so then the suspect or the accused can come out with that motive, why he did it. And that motive is very relevant to particular case. So that's why I said both parties will be benefited if we are in a position to come out with that motive position.
Mr. Yorasilla, in your wealth of experience in a long criminal practice, what do you see that should be done by people, society, governments, law, everything, to reduce the amount of crimes in Sri Lanka? Overall.
Yes.
It's a very social question, it's not a legal question.
That's right. So that's a good question to answer, because we have a duty. So as criminal practitioners, what we do is we are assisting court. So if we are in a position to assist court to get the justice done very quickly, without prolonging it, without dragging this, and that is how we can help. And if the prosecution can immediately get the investigations done and file the cases, so then the people will think that there won't be any delay. So, and finally, with regard to the community, they should have that power and then confidence to go to a police station and report these crimes immediately, and they should give assistance to the investigators. Otherwise, we will be in a position to say that laws are delayed. Those delays are there. So instead of that, if we can get together and work hard, then in most of the areas we can curtail the delays and do justice to the society.
Mr. Yorasilla, thank you very much for those insightful thoughts, and thank you for the efforts you're taking to change the laws and update it to suit the present society. Thank you for joining
so much.
Law and Order today. That's Law and Order for you today. You can join the conversation of this program on our Facebook page. Go to Facebook/Law and Order Channel Live, Facebook/Law and Order Channel Live, and you can log into that page, send us messages or make your comments on the program and tell us what we should do more to help you be aware of the law of Sri Lanka. I'll see you next week at the same time. Have a good night and a good weekend.